Let's take a look at a statement from Elaine Bredehoff. She said, "This is the perfect time to pass the baton. I have pledged to Amber and her appellate team my complete cooperation and assistance as they move forward on a path towards success." Think tank still with us. Darnell, Crosland, what's really going on here?
Well, she's filing appeals. So a lot of times you have trial litigators who aren't really prepared, or it's not their specialty to do appeals. But I think she did the right thing by saying that she'll assist the appellate team, because it's important for the appellate team to know the entitled transcript from the trial and to know the demeanor and the tone of the witnesses and things that the trial lawyer might have picked up that the appellate lawyers won't. So I don't see anything bad with that. Nothing bad at all.
All right, let's take a look at Amber's new attorneys. Defended the New York Times against Sarah Palin's defamation lawsuit. Represents journalists, news organizations, documentary filmmakers. And David is a former federal prosecutor and first chair trial lawyers. Here's their statement. "We welcome the opportunity to represent Ms. Heard in this appeal, as it is a case with important First Amendment implications for every American. We're confident the appellate court will apply the law properly without deference to popularity, reverse the judgment against Ms. Heard, and reaffirm the fundamental principles of freedom of speech." Jennifer Brandt, is this about the First Amendment?
Well, according to them, it is. And I think that, I agree with Darnell. Coming in as new counsel, it's a new case, really. It's an appeal. I think it gives Amber a fresh start, and a new court is going to be looking at this, and maybe she wants some new people to come up with some arguments for her, some different arguments for her.
Al, the First Amendment doesn't protect lies, does it?
No, it does not.
Then how is this a First Amendment case? The jury said she lied. They didn't believe her. They listened to her for a bunch of days. They didn't believe her.
The interesting thing is that her trial counsel didn't argue First Amendment either. I don't really remember that they set up an argument along those lines. I don't remember having any con law experts come in and talk about what constitutes free speech and what constitutes speech that's not protected. And, certain lies may be protected if it's an opinion that maybe is based on your representation or what you thought you saw. That's not necessarily a lie, and that may be protected. But the bottom line is that, as I understand, when you move to the next level, you had to have argued that in the lower level in order to be able to go forward. Like I said, these guys are real good con law lawyers. They're from Philadelphia. They know their stuff. They did a great job in the New York Times case just recently, and they know con law like there's no tomorrow. But that's what they were arguing throughout, was a con law thing. And so I'm a little, surprised that they're doing this at this point.
Vinnie, if I can add two things. One, they can appeal sua sponte, which means they don't have to show that there was errors in the lower court in order to have an appeal. That's the first thing. The second thing, I'm surprised the Playboy King hasn't mentioned Larry Flynt, Hustler. He was one of the biggest cases on free speech, and that was a great show of what the First Amendment covered. So Al needs to get
except that Larry Flynt didn't own Playboy. Larry Flynt is not Playboy.
I didn't know that Al was the Playboy King.
Yeah, well,
he is, and Italian and American versions.
And that was actually a classic court TV trial back in the day, by the way. Here's a statement from Amber Heard's spokesperson. "When it comes to protecting the fundamental right of freedom of speech, we look at the jury's decision to paraphrase a famous quote, not as the beginning of the end, but merely the end of the beginning. A different court warrants different representation, particularly as so much new evidence is now coming to light. I don't fully understand this whole thing, but to me it was pretty clear that the trial was he said, she said. Yeah, there were a bunch of other witnesses around, there were a bunch of recordings, etc. But at the end of the day, they didn't believe her. You don't have a First Amendment right to lie. You just don't. I know he's a public figure, but the argument was very clear that she was lying about something that she had firsthand knowledge of. So if they believed she was lying, she knew she was lying about it. Jennifer, I'm trying to see where they're going to go here, unless they're going to get the jury to say, we lied, we really believed her.
I think they're going to go, I would think, and I don't know, but I would think that they would go more about, you know, her putting her statements out to the newspaper, and this is what she believed. I understand your point, Vinny. The jury said that she lied, and it wasn't true. And I get that, but I think this is more.
So
about
what you're saying is, wait, I just want, because I think you're making a great point right here, by the way, like you always do.
Thank you, Vinny. Thanks, Vinny.
But in her own mind, she didn't think she was lying. She really saw herself as a victim of domestic violence, and that's why it was her right to speak.
That's what I think. I mean, she was airing out what she believed to be her truth. Maybe the jury didn't find that it was true, but
well,
in her mind, this was her truth.
Let's talk about that. That's an important piece of this, Darnell. When we say, because that's a phrase a lot of people are using now, my truth, like it's my truth. But does my truth matter in a defamation case? Isn't it just about the truth?
Well, it's really two things with the appeal: United States versus Strickland. So we haven't heard that come up yet, but and they're trying to be nice to each other with the appellate team versus her old lawyer. But they're going to obviously argue ineffective assistance of counsel at one point, and they're going to say that she failed to, as Al said, point out that there's protected free speech. She failed. Her trial lawyer failed to bring out those constitutional experts to talk about what's the truth or what's not or what's protected. We didn't see a lot of that. So when you look at United States versus Strickland and saying that your lower counsel was ineffective, then they get a chance to argue sua sponte things that they didn't argue before. And I think that's where we're going to be heading.
Okay, Al Wunsch, final question to you. You ready? Which is more likely? Which is more likely? A sequel to this trial or a sequel to the Pirates movie?
I think it's going to be the Pirates movie, Vin. But let's just remember what the great philosopher George Costanza once said. It's not a lie if you believe it.
Yeah, well, there you go.